Again. So I hope everybody had a good time in the bar last night, or other places, perhaps at the EFF Summit. If you didn't get a chance to give them some money or donate, they'll still take it at the table upstairs. I've got a few giveaways from our lovely sponsors. Anybody want a cozy for their beer?
I deserve one.
Okay, so just because it looks like I have a jock shirt on doesn't mean that's going anywhere. We have, from our friendly folks at BlackBerry, who I'm sure would love for you to check out their rim jobs website. And lastly, from our friends at No Starch Press, Forbidden Legos. Well, I'm not throwing this, so. I'm going as short a distance as possible. So, our first talk this morning is Marsha Hoffman from the EFF. She'll be talking about computer search and seizure. Yes, seizure. Yes. Enjoy.
Good morning, and thank you for coming out. I know it's an early talk. Can everybody hear me okay? Yeah? Okay, great. Good. My name is Marsha Hoffman. I'm a senior staff attorney at the Electronic Frontier Foundation and also a non-residential fellow at the Stanford Center for Internet and Society. Thank you. For those of you who are not familiar with EFF, we are a nonprofit based in San Francisco, and we work to protect individual rights in the digital age. Thank you. Thank you very much. We do a lot of work on a lot of different issues, but for you guys, I want to highlight that we have what we call the Coders' Rights Project. This is work that we do to try to help programmers and developers do the stuff that they want to do without getting into legal trouble. And if any of you have things that you'd like to talk to me about at this conference, please feel free to track me down. And I'd be very happy to talk to you now or at some point in the future over the phone, whatever. Please feel free to reach out. We also have a booth in the vendor area, so stop by and chat with my colleague Kelly, who is the nicest person you'll ever meet, and check out our awesome swag. So I'm going to talk today about computer search and seizure. This is a topic that is really interesting and evolving, and I hope you'll enjoy talking about it as much as I do. I'm going to touch on three things. I'm going to talk briefly about what the Fourth Amendment is and how it works. I'm going to talk about how the Fourth Amendment applies to searches and seizures of computers and the data stored on them. We're going to get into some of the exceptions and talk a little bit about border searches, which I know a lot of people are interested in. And then at the very end, I'm going to talk briefly about a really complicated subject, which is how the Fourth Amendment applies to data stored with others, data that's not on your computer but is stored in the cloud. So, a caveat. I think you're going to find this talk kind of frustrating because there are a lot of gray areas, and I think that programmers generally like to find the answer. And when we're talking about Fourth Amendment issues, the decisions here are made by judges, and they're human beings, and two human beings can reach a totally different decision about the same set of facts. And, frankly, a lot of these issues depend very, very heavily on the facts of that specific situation. And so if you ask me something like, well, what would a judge do in this situation? I can give you my best guess, but I can't give you a 100% sure answer. So I just want to warn you about that. If you have a problem with that, this may not be the talk for you. So just so you know. Okay, we're going to start with the Fourth Amendment. The Fourth Amendment is the amendment to the Constitution that protects us against unreasonable searches and seizures by the government. And this is the actual text of the amendment that was written more than a couple hundred years ago. And unsurprisingly, there's nothing in there about computers or data. And one of the struggles that judges have had is in figuring out how to apply this text to stuff that's not included in that amendment. So, how does this idea, how does the spirit of this idea apply to computers and to data stored on them? That's what we're going to be talking about today. So a couple of things about the Fourth Amendment to keep in mind. It applies only to government searches. So your right to be free from unreasonable search and seizure is only vis-a-vis the government, not against other, other people who are not involved with the government or other or companies. Yes.
What about private agencies working on behalf of the government?
It depends how closely they're working on behalf of the government and whether they're really kind of acting as, sort of an instrument of the government. I'm going to take one more question, but after that, I ask you to please, I will totally take your questions, but let me get through this stuff. But one more first.
Company can search employees' data?
Yes. Well, okay. Again, this is. So we'll get to this. There are some exceptions to the Fourth Amendment, and there are some exceptions that involve a government's ability to search a computer. If it's a private company searching an employee's computer, the Fourth Amendment doesn't even come into it because there's no government action, right? But if it's like, say, a government agency, searching an employee's computer, there can be Fourth Amendment issues, and it depends on the facts whether that's allowable or not, and it has to do with, an expectation of privacy, which we'll talk about in a moment. Okay, so only government searches and seizures. When we talk about the Fourth Amendment, we always start with this question. Does the person have a reasonable expectation of privacy in the place to be searched or the things to be seized? And that's always the first question that we ask. If the person doesn't, because, for example, this is something that they hold out to the public every day, and there isn't an expectation of privacy there, then there's no search, and the Fourth Amendment doesn't really come into play. If there is a reasonable expectation of privacy, as a general matter, the government has to get a warrant based on probable cause. Now, what does that mean? So, probable cause means it's more probable than not that the stuff that they want to search is going to reveal evidence of some illegal activity. Basically, the cops have to go to a judge and explain the probable cause, and the judge thinks about it and then decides whether or not to give them a warrant. And if they get a warrant, then they're allowed to do the search or the seizure. So that's the general rule, but there are exceptions. This is a non-exclusive list of the exceptions, but these are some of the most important ones. They don't have to get a warrant when you consent to the search. They come knocking at your door, can we come into your house? And you say, okay, come on in. They don't have to get a warrant. Plain view, that's where they have a right to be where they are, because let's say they've already gotten a warrant, and then they just happen to see evidence of some other crime, okay? So they get a warrant to search your house for evidence of tax evasion, and they walk in and they see cocaine on the living room table. That's plain view, and they don't need a warrant to seize the cocaine. Search incident to arrest. This is where you're walking down the street and they have, a warrant to arrest you, and they pat you down and they find, drugs in your pocket. They don't need a warrant to seize that. And we'll talk a little more about that one. That's a very interesting one these days. Just to give you a sense, though, the thinking behind that is that if a policeman is in a situation where he's, dealing directly with you, he should be able to make sure that you're not carrying a weapon that could cause harm to him, or that he should also be able to make sure that you don't have evidence of the crime that he's arresting you for that you could throw away or get rid of. So that's the general thinking there. So searches of cars, there's another exception here. If the police stop you and they have probable cause to believe that there is evidence of a crime in your car, then they don't have to get a warrant before searching the interior of the car, including containers inside the car. And exigent circumstances. This is where There's a situation that's going on. They're afraid that somebody might be able to actually, get rid of evidence of a crime before they could get a warrant. In a circumstance like that, they don't have to get a warrant before seizing something. So the exclusionary rule, here's the upshot. If there's a search that's done that violates the Fourth Amendment, what that means is that the evidence can't be used to prosecute somebody. So basically it just kind of gets thrown out and they have to rely on whatever other evidence that they've gotten. This doesn't apply if the cops have an independent source for the same evidence or they would have discovered it anyway. In that case, the evidence can just come in. Okay, so that's kind of the big overview. So let's talk about these concepts as they apply to computers. So the traditional scenario for Fourth Amendment searches and seizures is the physical world. These are rules that have been developed by the courts over hundreds of years, and they've generally involved, the way that people go about their day-to-day lives and the places that they are and the things that they have as they're living their day-to-day lives. So the traditional scenario is the house. You have great expectation of privacy in your house. The greatest expectation of privacy in your house, in your private space. If you're walking down the street, you don't have an expectation of privacy because what you're doing is out there in the public already, right? But keep in mind, as we're talking about these things, that these rules have developed in this context. And keep in mind, the house. So when judges confront new situations, they say to themselves, okay, so I've never had a Fourth Amendment case where I have to figure out how the rules apply to a computer, for example. So they will sit there and think, okay, what's the closest thing that we have decided? And then maybe that'll be the rule for the computer. So, they think, what's a computer like? I mean, what do you guys think? What is a computer like? I'm sorry? A drawer full of papers, like, filing cabinet or a, yeah, okay.
Where you keep your lifetime subscription to Playboy.
That's interesting. Where do you keep that? You don't have to tell us, it's okay. Is it like, think about the amount of data that's stored on a computer and the stuff that you have amassed in that little space. I mean, is it like a house in terms of what you have in there that you'd want to keep private? Is it like your house plus your office? Is it like a warehouse? I mean, what is it, right?
Like a library that fits in a briefcase.
There you go. It's like a library that fits in a briefcase. That's an interesting way to put it. That's very literal. And yet, of course, judges never have had to deal with that because there's no such thing, right, except computers. So judges have basically kind of said, okay, well, a computer, it's like a box, it's like a container, So I choose a suitcase because, it is also a container. And I think that this is, a way that we can think about this. So, some judges say, okay, so a computer is just like a container. Okay, so you have a reasonable expectation of privacy in a container that you carry around with you and that you have. And judges have generally agreed that you have a reasonable expectation of privacy in your computer because you would have a reasonable expectation of privacy in some container that you had. Other judges have gone further and said, a computer is like a container that has other containers in it because there are disks that are separate. And so it's like a container with containers. And then, so, each of those containers is something you might have a separate expectation of privacy in. So that, if the cops wanted to search what's on the computer, they might have to get a different, they might have to get a different warrant for each of those containers, all right? So that is one interesting way where the courts have kind of diverged a bit. So if a computer is a container, what are the files stored on a computer like? Piece of paper? I'm sorry? Books? Anybody else?
Ledgers, papers like that.
Uh-huh.
Personal. Might have your accounts, information.
Okay. Credit cards in your wallet? Your life, yeah. Courts have gone different ways on this one too. Some courts say files are like containers. And so if you want to take a look at a certain file, you need to get a warrant for that as a general matter. Other courts have said that once the police have the authority to search the big container, the hardware, the computer itself, then they can search anything in the container. So that is a big difference, and that has big implications.
How would that come with briefcases? I mean, if you have like a little, like a lease inside the briefcase or even a locked little box, how do they go on that? That's something presumably they have seen before.
Well, yeah, as a general matter, assuming that, it's not one of the exceptions, right? Like, they find it in a car or something that they've stopped. I mean, they would need a warrant to search the briefcase, and they could look at everything in it. But, if there was like a closed package in there, I mean, that might be a different matter, right?
If there's a locked box in there, they don't need to send a warrant for that.
I think it might depend on the circumstances. It might depend on the circumstances. I think if they had a good reason to think, if they had probable cause to think that there was something illegal in there, then they might not. But if it's a locked box, well, it's fact specific. Let's put it that way. It depends on what they have reason to believe. All right. But the upshot what I'm trying to get at here is that search and seizure of digital information is very different than in the physical world, and the courts are really struggling to figure out how to apply these traditional rules to this new type of thing to be searched, because the traditional rules just don't fit. And there are a few reasons for this, and this is a non-exclusive list. I'm sure you guys can think of some good reasons too, but the ones that kind of come to me and just immediately pop into my brain is that when we're talking about the physical world, they generally search and then seize. They go into a space, they have reason to believe there are certain things that they're interested in, and they take those things. But when we're talking about computers, what they normally do is they'll mirror the whole drive. So they seize that information and then they search it. And they've got all of that stuff. And how do you deal with the fact that they have all of that stuff? Is that something, should the cops be imposing rules on themselves as to how to sort that out? Should the judges be making them sort it out in certain ways? Those are all things that are very much in play. Another difference is the sheer volume of the data. I mean, like I said, they get everything, right? They've got all this stuff that they could go through, which just really isn't the case when they're seizing physical stuff. Then there's the sensitivity of the data. I mean, think of all the things you have on your laptop and the portrait of your life that it paints. I mean, you've got your communications with your friends, your family, your coworkers, probably going back years. You might have tax information on there. You probably have, confidential business information on there. I'm a lawyer. I have attorney-client privileged and work product information on there. Think about, just the sheer sensitivity of the data on your computer, especially as a whole. And then there's the intermingling problem, the fact that there may be things that they want to take a look at, but they have to figure out how to find it. And how do they search it? Do they have a right to go through every file to find the evidence described in the warrant that they're entitled to seize? And that takes us back to the exceptions. I want to tell you guys about a couple of really interesting legal issues that are playing out right now and are very, very live at this moment. One has to do with the plain view exception that we talked about earlier. I mentioned that this is a situation where, the cops are, kind of entitled to be where they are, and then they happen to see something else that's evidence of a different crime, and since it's right there in front of them, they don't need to get a warrant to seize that, right, or to use it. So there was a case recently at an appeals level, which is, pretty high level. There's the trial courts, they figure things out in the first instance. Whoever loses might appeal to the appeals court, and then whoever loses there goes up to the Supreme Court. So appeals court is, it's pretty high level. It has some real impact. So this is an appeals case, United States versus comprehensive drug testing. And this involves a situation where the US government was investigating steroid use in Major League Baseball, and they became aware that Major League Baseball had reached an agreement with its players where they were going to agree to be tested for steroid use, but those results wouldn't be used against them. It was to help Major League Baseball get a grasp on how big the steroid abuse problem was and whether they should step up the testing, in future seasons. And so the government became aware that this company, Comprehensive Drug Testing, had done this comprehensive drug testing of Major League Baseball players, and had a tremendous amount of information about it. And the government became aware of 10 baseball players that it believed were abusing steroids. And so it went to this company, and kind of in a complicated mess of legal requests, said, we want information. We basically want all the information that you have about the ball players. Not just the 10 that we have reason to believe have been using steroids, but all of them. We want it all. And Comprehensive Drug Testing pushed back against that because they were like, hey, we have a business arrangement with Major League Baseball. The idea here was that this was going to be confidential. We want to stick up for our customer, and we just think this is not right. I mean, you're totally overreaching here. And this was a case that got up to the appeals level, and the appeals court issued a really interesting opinion that kind of spanned a range of issues. But on the plain view situation, I thought that was really something. Basically, the government said, okay, so they went to the judge to get this warrant. They said, we have probable cause to think that at least 10 players have tested positive. We want information about them, but we can't possibly, we're going to need to get all of this data and then have somebody, sort it all out so that we can figure out what's actually relevant to our investigation. So we need it all. But, we'll take steps to, safeguard the rest of that information. And the judge was like, okay, and the warrant issued. And then the government took the position that since they had all of it and they had to go through all of it to figure out what was actually relevant to the investigation, that, the rest was plain view because they had to go through it all. And the court was like, no, that's really overreaching. So, I give you that example because it's a recent case, and I think it shows some of the arguments that the government has at times made to try to justify going through a lot more data and collecting a lot more data than really necessary. Another area of the law that's really active right now and is super interesting has to do with cell phones seized from people when they're arrested. Remember we talked about search incident to arrest. You're arrested. They pat you down. The cops are the cops are allowed to see what you have on you. And again, the rationales underlying this are officer safety and preserving evidence and making sure it doesn't get destroyed, right? So across the country, we've had these situations where, cops will arrest somebody, they take their cell phone, and, be it right there or, hours later at the station, they just go through the cell phone. And they're like, hey, we seized an incident to arrest. We don't need a warrant to look at the cell phone. And there's a split among the courts. There was just a ruling in the California Supreme Court. It was a state court, but it was ruling on the Fourth Amendment issue. The California Supreme Court said, hey, it's something that they seized off a person. It falls within the exception. They can look at it. It's simple as that. The Ohio Supreme Court has gone the other way. And the Ohio Supreme Court says, you know what, a cell phone has a ton of stuff on it. It's not like you're just looking through somebody's wallet, really. It's not like you're, looking inside a pack of cigarettes to see if somebody, stuffed some drugs down there. It's totally different. A cell phone, really it creates a heightened expectation of privacy because of the amount of stuff on it. And, you just can't peruse a cell phone because you arrest somebody. And then, on the federal level, courts across the country have gone different ways on this. So this is something that is still very actively being played out. I think this is a question that could end up going to the Supreme Court.
Very quickly, do they deal at all with the fact that a cell phone attaches to larger data stores than what's local to the cell phone? Especially in the instance of Android and some of these other cloud computing-based phones. You seize the phone, that's fine. Maybe you have access to what's in local memory.
That's a super point, and that was not addressed in the opinion. I don't think the judges thought about that. And to be honest, a lot of the decisions that I've seen have involved, cell phones that are not like iPhones or Android phones, not smartphones. They're more, the littler ones, the ones that have fewer capabilities, but they're still pretty sophisticated. And, I've yet to see a court really grapple with, gosh, this is an iPhone with all of this stuff on it, or, this is an Android phone, or, this is a phone with the capabilities that you just described. I've yet to see a court deal with that. We're going to talk about that in a little bit. Okay, we're going to talk about passwords and encryption keys briefly. So I want to talk very briefly about a special Fourth Amendment situation, which is searches at the border. Now, the Fourth Amendment applies at the border, but the courts have decided that searches at the border are considered reasonable. Remember, the Fourth Amendment protects against unreasonable searches and seizures. Searches at the border are considered reasonable simply because they occur at the border. And the rationale underlying this is that border agents need to be able to make sure that people aren't carrying contraband into the country and what have you. So they need to be able to search stuff. So what the Supreme Court has said is that as long as a search is routine, then no suspicion of wrongdoing is necessary. And the distinction between routine and non-routine is like, how invasive is it? And the courts have said it has to be super invasive before it's non-routine. I mean, it's basically like, a search of your alimentary canal, like if they think you're smuggling drugs into the country, okay? So, I mean, there were arguments made in various cases that a search of a laptop is not routine because of the sheer amount of information on it and the sensitivity of it and the comprehensive portrait of a person's life that it paints. It's simply not like a suitcase or a briefcase. It's something totally different. But the courts haven't bought it, unfortunately. And so the way that the law stands, if you're carrying a laptop over the border, agents can search it for no reason whatsoever. So what can you do about that? A lot of people contact us and they say, look, I have to go, out of the country on a business trip. I've got all this, proprietary information that's, confidential. I don't want it out. I don't want the government to see it. My employer doesn't want the government to see it. Is there anything that I can do? And so, at EFF, we've kind of put our heads together and we've thought about it a bit. And, our thinking on this certainly evolves. And if you guys have ideas, we'd love to hear them. But, this is kind of what we've come up with so far. So first of all, consider having a laptop or a hard drive that you use specifically for travel. And basically have it be empty except for only what you need. So take only what you need with you on your trip. And if you can, securely delete the information on the hard drive before you come back. So it's basically just empty. They can search you when you're leaving or coming back in. They're more likely to search you when you're coming back in. So, if this is something that you're worried about, take as little with you as possible. And if you can, delete it securely before you come back. And also think about keeping your data stored somewhere else. And this is for two reasons. Number one, if your computer gets seized, you may be without your data for a while, so make sure you have a copy of it somewhere. But also, you could take a completely clean laptop with you, download the information once you get to your destination, do what you need to do with it, and then wipe your computer before you come back. So that's a thought as well. There are some issues with that because law enforcement can still get data that's stored other places, and with the right legal process they can intercept communications and stuff. But having them have to do something to get your information is better than them having to do nothing to get your information, which is the deal at the border. Use passwords and encryption. Encryption is the most important thing. Encrypt your data. Very important. Passwords are certainly not fail-safe, but they provide at least a little bit extra protection. And I think that they certainly do give you an argument down the line that you have demonstrated a reasonable expectation of privacy in your computer, should that ever be an issue. A word about passwords and encryption. If they ask you to disclose your encryption passphrases or passwords, you're not obligated to turn them over. And if you voluntarily give them up, then you've obviously consented to let them have it. You're under no obligation to do that. There have been a couple of interesting cases where people have traveled over in one case in particular, somebody came over the border and his computer was on, and a border agent found what he thought was child porn on the computer and seized it. But after he shut the computer down and then tried to reboot it, it turned out that that information was in an encrypted spot. And so they tried to get the guy to disclose his passphrase. And the judge in that case found that doing so, or like requiring this guy to do that, would actually violate his constitutional privilege against self-incrimination. That privilege protects you from having to give testimonial evidence against yourself. And when I say testimonial, I mean speaking it, like disclosing the contents of your mind. Basically, somehow tying yourself to some activity that the government might want to prosecute you for. And, the judge said, look, if he has to give you his passphrase, then, he's basically admitting that he has control over that activity and you can't force him to do that. So that's something to keep in mind. Something else I want to flag about that is that that privilege does not protect against records that already exist. So if you have your password or your passphrase written down somewhere, that's more vulnerable, okay? So just so you know. You had something you wanted to...
Of these two approaches, is there one that is less hassle or more recommended than the other?
So I'll tell you, I think that these are all, you could use all of these approaches or one of them. I think it has everything to do with your circumstances, like how much hassle you want. Are you a US citizen or not? Like, do you have worries about not being permitted back into the country? How comfortable do you feel getting into what might feel like a weird confrontation with border agents? I think it has everything to do with your data and the way that you feel about it and, kind of the amount of effort you want to put into safeguarding your data. So I consider these all options. You can use any one or all of them. And also, we have a blog post on our website that we put up there in November that, this slide kind of distills the information, but there are more details. So, if you're interested in this stuff, do a search for like EFF and, I don't know, like guide to border or something like that, guide border, it'll come up. It's basically called like our guide to border searches or guide to securing your digital information at the border. Yes?
The question is, are you looking at the implication of the other nations who never cross only one border?
Oh, I know, that's absolutely true. And I gotta say, I'm a US lawyer. I don't know the laws at the border in other countries. I can only help you at the US border. We haven't looked into those. And this is advice for the U.S. border in particular, although a lot of these are technical things that I should hope would help you other places too. It's not just a matter of law.
Given the 100-mile range for the border,
Yes.
does this apply only to crossing or within that 100-mile range, say in Taiwan, Virginia, which is where I live, I arguably live within 100 miles of the border?
Yeah, so that is a super interesting question, and actually there's a lot of play in the law here too. So while the border is a place where you have, where government agents can search your laptop without any reason, things change if they decide to keep your laptop for a while and/or they take it away from the border. There's a case going on in California right now in the Ninth Circuit Court of Appeals, still being decided, where this guy came across the Mexican border and they seized his laptop and they took it to a place for forensic examination that was something like 180 miles away, and they kept it for 2 days. And the district court judge said, well, in that case, that's not a border search anymore. If you're going to do that, then you have to have at least reasonable suspicion to search the computer, and you didn't have that. So, that's been appealed, and so that's a question that is very, very much in play, and I think that that's a very fact-specific question. How far away did they take it? How long did they keep it? I think your question is a little bit different, which is, how far does the border extend? And, I have to say, I haven't seen any cases dealing with that. I feel like there is some, it's not like just at the crossing point, right? Or just at the airport where that's the functional equivalent of the border. I think they have some latitude to take it away. Yes?
Relatedly, I assume it's not just being near the border, but if I'm like driving around in northern New York and I happen to live in that area, and there's never any evidence that I intend to cross the border at that time, even if I come within 2-3 miles of it, I assume if it's pretty clear that I don't intend to cross the border, that they can't really use border rules, or can they?
I'm not sure, but it's an interesting question. I mean, I think you could argue it either way, right? I mean, if
But is there any case law about it?
not that I know of. I mean,
Border checkpoints in the south of the U.S. If you drive I-10 across the border control, actually has multiple checkpoints that are well within.
right. And I would assume in situations like that, the border rules would apply. That's what I think. But I mean, if some cop pulls you over, on some, back road near the border for speeding or something, I'm not sure, how it would fly if they use the border exception to search your laptop.
But border control can't apply this crossing the border exception in there in the gray area if you aren't actually crossing the border or coming in and out, right?
That's the question.
Well, yeah, and I have to say I don't know the answer. That's a good one.
Because I've been stopped traveling in northern New Hampshire by immigration.
Yeah.
I don't know, like 60, 70 miles south of the border, and they were stopping everybody on the highway.
Right.
Say they were interested in you as a suspect in something and they could claim intent to cross the border?
I don't know. Good question. Good question. I mean, these are things that are, beyond the scope of my knowledge of this subject, but these are all really good questions. Let me, if you don't mind, let me continue. And let me just finish this up and we'll talk more about this stuff. So I want to briefly talk about searches and seizures of data stored with third parties. So I'm sure all of us, or at the very least, the vast majority of us, have data that we store elsewhere in the cloud. It's in the control of other people. So putting aside the Fourth Amendment rules for just a second, I want to say that there's actually a bunch of laws that regulate how the government can get this kind of data. In the United States, we have the Wiretap Act, which applies to communications that are actually on their way from A to B, and how the government can intercept those communications. And that law requires, a full warrant. The Stored Communications Act applies to situations where the government wants to get records of your communications or your subscriber records from, a third party like, say, Google or Yahoo or whoever. And it's a very complex, statutory scheme, but as a general matter, if they're looking for content of communications, like the content of your email, and your email is less than 6 months old, they have to get a warrant. If it's older than that, they don't necessarily have to get a warrant. They could use some lesser process, is what the law says, and keep that in mind. We'll put a pin in that. And then, for subscriber records, it's also a lower requirement, a lower burden they have to meet. The PIN Register Act regulates how the government can get routing information. This is the information that gets a communication from A to B. And that, again, is a lower standard than a warrant. And then there are state laws in every state that cover this ground as well. So, it's very complex, a lot of stuff going on here. But that doesn't answer the question of what the Fourth Amendment requires. So, Congress can say, the government needs to do X, Y, and Z to get this data. But, if you have a Fourth Amendment right to have that data protected, then, the laws would be unconstitutional if they require, anything less. So, let me ask you this. How many of you think that you have a Fourth Amendment expectation of privacy in the email that you have stored with a commercial ISP? Nobody thinks so? Not sure?
I can see a difference depending on the context. Because say you take Google on one side, if you just have a Gmail account, I expect the government to have an easier time getting that versus if you have a domain doing corporate service or something like that, because that's more of a service that they're providing, but there's still, I see a higher level of expectation of privacy there.
Yeah.
Personally.
It's also between something
Uh-huh. Right. So this has been a surprising gray area. And, you know, at EFF, we've been very concerned about a couple of Supreme Court cases that, you know, basically stand for this idea that if you voluntarily disclose stuff to a third party, then you don't really have an expectation of privacy in that stuff anymore. And, you know, we've been worried that that precedent is going to get applied to email because, you know, that would be a terrible thing if you don't have any expectation of privacy in email and the government doesn't need a warrant to read it just because you know, you have a Gmail account or whatever. So last month, this case came down, United States versus Warshak. It's, again, an appeals court, so it's pretty high-level precedent. This is the first appeals court to ever rule that you have a reasonable expectation of privacy in your email stored with a commercial ISP. And you know, I mentioned to you that the Stored Communications Act says that if your email is more than 6 months old, they don't necessarily need a warrant. So this decision calls into question whether that law is unconstitutional or not. And that's a very interesting thing that I think is going to get sorted out within the next, you know, I'm hoping, you know, in the next congressional session, because I think this means that Congress is going to have to go back and update, you know, that regime of laws that I just showed you, which dates back, by the way, to 1986 and has never been really substantially updated. So it's really out of date.
Is there a real-world analog to that, such as when you have a Keto box with a third party that would have similar rules around this that they could kind of compare? You know, like if you rent a box from a UPS or something, a Keto box, that's not the postal service, can they go and search and grab the mail out of that location? Bank records.
Bank records. Well, you know, bank records. One of the Supreme Court cases that I just mentioned had to do with bank records. And you know, the Supreme Court said, hey, I mean, you voluntarily disclose this information to the bank. You know, you don't have much expectation of privacy there because, you know, I mean, you gave it to them, right? I think this situation is a little bit different. The one that you mentioned, you know, like when you like rent a space, you know, because, you know, you have, you know, contracted with somebody to have special rights to that space, and so. You know, I think that you demonstrate a reasonable expectation of privacy there, and surely, you know, I have a hard time seeing a scenario. I mean, I'm sure I could gin one up, but I think as a general matter, the cops would need a warrant to search a space like that.
That suggested kind of agree that whatever your terms of service basically.
Right, terms of service is an issue, right? And that's actually what the government, one of the government's arguments in Warshak was, you know, hey, you know, terms of service say that the company can look at it, so. And the court said, you know, it can't be the case that every time there's a terms of service you bargain away your, you know, any expectation of privacy you might have. So, you know, I thought that was a very good outcome. The court said it could imagine a scenario where there is a terms of service where you'd bargain it away, but they didn't want to, you know, they were like, that shouldn't be the rule. That should be the exception. Yes?
In the United States versus Warshak, was that a for-pay contracted service, or was that like a free service?
I think it was a for-pay contracted service. Yeah. Mm-hmm.
Say the, you know, government goes after like your Gmail or anything.
Mm-hmm.
Is there anything that, you know, Google can like, are they allowed to say that, hey, the FBI is looking at your stuff, or are they even allowed to?
Yeah, so it depends, but as you know, the general rule is that subscribers are entitled to notice, or in certain cases, you know, the company can give notice to let them know, unless the government, you know, convinces the judge, and it's in the warrant, that, you know, the subscriber knowing would, you know, have a negative impact on the investigation, and, you know, the subscriber really shouldn't know. But, you know, you just mentioned national security letters. There's a gag provision that goes along with that. You all may be aware of the situation in which the government sent or issued an order to Twitter for information about certain subscribers who they were looking, whose records they wanted to look at in connection with an investigation into WikiLeaks. And there was a gag order associated with that, and you know, somehow Twitter managed to get that lifted. And you know, we think that's what companies ought to do. You know, I mean, they should be having the rights of their subscribers and customers, you know, first and foremost in mind, and should give them the opportunity, where possible, to contest an order like that. And you know, we thought Twitter did a very good thing there.
That makes me wonder about Facebook.
Yes?
In your last slide there, you said specifically about commercial ISPs. How is that defined? How do you interpret that?
Well, you know, I used the term commercial ISP because that's actually the term that the court used. You know, I take that to mean a company that provides internet services for profit. And, you know, I think, frankly, I think it would reach Google or, you know, I think just because a service is free, you know, the fact that you pay or don't pay, I don't think is determinative, okay?
But what if it's not a company that hosts it? I have a server that I let my friends email on. Hey, am I an ISP or am I just a...
I would argue that you're an ISP. I mean, you know, in terms of the expectation of privacy, I don't see that that should be a fact that makes a difference. But, you know, who knows? I mean, if that were ever a case that were litigated, perhaps somebody would make an argument the other way. But, you know, I think just from a common sense perspective, it would make sense that they would have the same rights with your service as they would with, you know, a service like the one at issue here. Yes? So, you know, this is, you know, I mentioned before that I think Congress is going to have to go back to the statutory framework there that regulates access to communications because, you know, there's some question now about whether those things are out of date. But, you know, this is a constant issue, especially when it comes to technology, which evolves all the time. You know, the way the courts work, the courts handle things on a case-by-case basis. Congress is in a better position, and you know the state legislatures also are in a better position to handle things more holistically. And I think there's a tension there and a balance there. But you know, the fact of the matter is the laws get outdated pretty quickly when you try to apply them to things that, you know, Congress never contemplated 20 years ago would exist. And, you know, so there's always this question about, like, how, you know, what kinds of laws should they be trying to make? You know, should they be trying to make laws that are vague enough that they're going to cover, you know, things moving forward that they may not even contemplate, and then there might be some unintended consequences there, or should they be very specific and then just expect to update things quite a bit, but then that's a big, you know, kind of time commitment. So, you know, it's a very interesting question about how to handle it. You know, I think the courts, you know, just because of the nature of how courts work, you know, they will always handle things on a case-by-case basis because, you know, they resolve controversies between people and companies, basically, you know. So, you know, I think, you know, they will continue to do things on a case-by-case basis. Yeah.
So, on a strategic level, and given the history of legislation associated with technology, the EFF in general, if there's an area where it's obviously unclear, but there doesn't seem to be anybody interested in putting legislation in pipe, good or bad. Or do you think the sleeping dog good, or do you say, well, we should get in there and try to make something good before, or I mean, encourage, you know, talk to the legislators before anything happens? Because I can see a good case for leave it alone, because whatever they do is going to be much worse than nothing.
As a general matter, we are not very big on government regulation. You know, we feel like technologies flourish better and innovation, you know, innovation moves forward better when there's less regulation on companies. So, you know, we're not big proponents of sort of, you know, preemptively trying to get regulation in there to, you know, to guide the way that things are going to go. You know, we'd rather see situations where, you know, there's legislation that addresses a problem. So as a general matter, you know, I would say we would let the sleeping dog lie. 2 minutes? Okay. Maybe a couple more questions if anybody has them.
The back behind the lights.
Oh, yes.
It's a little bit off topic. Can you talk about the case with Sony being granted the TRO against George Hotz and the fact that it has seizure of his computers in it?
I'm sorry, could you say that again?
Yeah, so Sony was granted a TRO against George Hotz, and it had including a
Right.
seizure of his computers. Can you talk a little bit about that?
So there is actually not a whole lot that I can say about that particular situation. What I can tell you is that we're very concerned about it, and we're involved. And I did a blog post with my colleague Corinne McSherry a couple weeks ago talking about the concerns that we have about that case on a broad level. We think that that case seems to be one in which Sony is trying to send a message to security researchers that they shouldn't be doing the stuff that we're doing. And we have some very big concerns with some of the claims. But aside from that, I would say, if you're interested in that case, just keep an eye on the EFF website. And that's all I can really say about it. Yeah.
Can all this laws and requirements be overruled by the Patriot Act? They can just search and seizure computer data from the Patriot Act?
Well, so the Patriot Act is legislation, and any legislation that's unconstitutional can't stand. And so, to the extent that you have Fourth Amendment rights that are secured by the Constitution, any legislation that would try to take away those rights would be something that we and others, like the ACLU, would attack in court. And I feel very good that we would win. Yes, behind.
It seems to me that a lot of this unsettled law, that's what it is, right? Unsettled law is when I can take either side of the case with some probability, that's unsettled law. It seems to me that a lot of it hinges on where is the private line, what is private, what is not private. For example, in Germany, you have to take an action to secure your stuff, or otherwise you're violating the law in some cases. Whereas in the United States, you can run wide open Wi-Fi from your house. You can put an SSID on it that says John's house, which is publicly visible. And so, how is all of that going to get resolved? How do you think that that's eventually going to get resolved? Dividing line was private and what was public.
No, I think that that's a great question, and it's complicated by the nature of technology. The way that the Fourth Amendment rule works now is, the question of whether you have a reasonable expectation of privacy, there are two parts to it. Number one, did you actually do something that demonstrated that you personally thought this was private? And then the second one is that an expectation that society is prepared to recognize as reasonable, right? And, I think when you apply those tests to what you just mentioned, like open Wi-Fi, it starts to get interesting. I mean, if you encrypt your data or something, I think that's certainly something that would satisfy the expectation of privacy test. But if you're just sending stuff over an open Wi-Fi, that starts to get tricky, right? I mean, especially when emails in general. I mean, as we talked about, content, right? I mean, when you send content to somebody, the government shouldn't be able constitutionally to get that stuff without a warrant. And yet, if you send it over open Wi-Fi, it's a difficult question, and it's one that's not resolved yet. Well, yeah, I mean, the Google Wi-Fi incident implicates this too. There's no government action there, so that doesn't, the Fourth Amendment doesn't come into play there. But I definitely think you've pinpointed something that's one of these tough cases that the courts haven't really figured out how to deal with yet. So I think I need to wrap up, but thank you all, and thank you. I'm going to be around the rest of the weekend, so if you want to continue talking, please flag me down. Thank you. Thank you. Thank you. I appreciate it.